This is Shashank Mishra, today's host. Welcome you to the new episode of Law and Life. I will be having conversation on topic fundamental duties with the renowned senior advocate of Supreme Court of India, Subodh Markandeji. So my first question is, why do we need the fundamental duties?
Rights and duties are inseparable twins. States' duties are citizens' rights, and citizens' rights are states' duty. So there is no escape from this.
Kindly tell us how did this provision evolve under our constitution?
So even before India became, dominion of India under the India Independence Act on 15th of August 1947, the process of framing the constitution had already started with the first meeting of the Constituent Assembly on 9th December 1946. The task was completed in less than 3 years with the adoption of the Constitution by the Constituent Assembly on 26 November 1949, which is now celebrated every year as the Constitution year, as the Constitution Day. The Constitution of India was inaugurated on 26 January 1950. It is world's longest and most complicated constitution. In its scope and reach, it's a monumental document, but like all human endeavors, it has several deficiencies, which were sought to be remedied later on by enacting more than 100 amendments within the span of 75 years. One such deficiency was that the constitution was heavily loaded with emphasis on citizens' fundamental rights with no provision for their corresponding fundamental duties. This is understandable because people of India had been deprived of their most basic rights during the centuries of despotic rule, that is, under the British and even earlier. Therefore, conferment and safeguarding of fundamental rights was uppermost in the minds of our founding fathers. Justice Durga Das Basu, in his Tagore Law lectures in 1968-69, was perhaps the first one to draw our attention to this deficiency in the Constitution. This deficiency was remedied by 42nd Amendment, which amongst other things added Part 4A. Part 4A of the Constitution has just one article, that is Article 51 capital A of the Constitution.
Are there any provision parallel to Part 4A elsewhere?
Yes, there is Article 29 1 of the Universal Declaration of Human Rights, 1948. Then there are Articles 59 to 69 of the Constitution of the Union of Soviet Socialist Republics, which was framed in 1936. Then there are Articles 12, 26, 27, and 30 of the Constitution of Japan of 1946 and Article 12 of the People's Republic of China, China's constitution. Yeah.
But the 42nd Amendment to the Constitution has been so much criticized.
Initially, the legitimacy of 42nd Amendment was highly suspect. It was enacted during the emergency on the basis of the recommendations made by what is called Swaran Singh Committee, appointed by the President of the ruling Indian National Congress. At that time, most of the opposition leaders and even some Congress leaders were under preventive detention during the emergency. The deliberations of the deliberations relating to changes of far-reaching character in the constitution were confined only to the party in power, with very little public participation. Swaran Singh Committee had suggested the empowerment of Parliament to impose punishment for breach of fundamental duties. But that suggestion was dropped in the bill which was introduced in the parliament, which ultimately culminated in the uh, 42nd Amendment. Speaking in the lower house of India's parliament, the then Prime Minister Indira Gandhi on 28th October 1976 had said that the object of fundamental duties is not to smother rights but to establish democratic balance. When the Congress government was defeated in 1977 for the first time in 27 years of the history of Republican India due to emergency excesses of the Gandhi government, the newly formed Janata Party came into power and it repealed most of the partisan provisions of 42nd Amendment. But Part 4A relating to fundamental duties of citizens was retained as it was thought to be a salutary provision. Now, we had a National Commission for Review of Working of the Constitution, which was constituted on 22nd of February 2000 under the chairmanship of former Chief Justice of India, Mr. Justice M.N. Venkatchalaya. And in the report, that commission suggested the following twofold measures in regard to Part 4A. These measures are inclusion of the following as fundamental duties, that is, duty to vote at elections and actively participate in the democratic process, then to pay taxes, then to foster family values and responsible parenthood in the matter of education of children, and lastly, to require the industrial organizations to provide education for the children of their employees. And the second recommendation was earliest operationalization of the recommendations of Justice J.S. Verma Committee on the teaching of fundamental duties to citizens of India, including as part of a school curricula throughout the country. Justice Verma Committee, it may be recalled, had submitted a detailed report in two volumes running into 425 pages on 31st October 1999. It contains a list of summary of as many as 138 cases decided by the Supreme Court bearing on Part 4A, and it was published by the Ministry of Human Resources Development, Government of India. Originally, 10 sets of duties were enumerated in clauses A to J of Article 51A. In 2002, on the insertion of Article 21A creating the fundamental right to education, corresponding fundamental duty was imposed by adding clause K to Article 51A. Clause K imposes on parents or guardians of children between the age of 6 and 14 the fundamental duty to provide education to their children or wards as the case may be. The fundamental duties have thus come to stay in the Constitution of India.
What is the scope and effect of Article 51A?
A host of questions arise in regard to the fundamental duties. Are they per se enforceable? And if so, by whom? Are they addressed to the state as defined in Article 12, that is, institutions and entities, constitutional and legal? What are the consequences of disobedience? So, in my view, Part 4A, like Part 4, which deals with the directive principles of state policy, seventh schedule and other relevant provisions of the Constitution is a veritable source of exercise of legislative and corresponding executive power. At least the Supreme Court, with its vast and inexhaustible judicial power under Article 142 of the Constitution, can, and as shown by the report of Justice Verma Committee, has indeed used Article 51A as a source of its judicial power, at least in the field of environmental protection. Another aspect that needs to be noted is that by their very nature, all duties, whether fundamental or otherwise, involve a degree of compulsion. There can't be any duty without compulsion. Consequently, imperative rather than permissive approach in enforcing the fundamental duties is the correct way to construe Article 51 capital A. Moreover, the cascading effect of interpreting one clause will have on the other clauses is a necessary input in this interpretive process, where each of the fundamental begins, the fundamental duty ends. To illustrate, the fundamental right to freedom of speech and expression ends where the duty under clause A begins. In other words, there is no fundamental right to flout constitution or to disrespect its ideals and institutions or the national flag or the national anthem. I may add that abiding and respecting has to be to the fullest extent and there is no halfway house. Therefore, use of national anthem and national flag to crass commercial purposes, disturbing the hoisting and unfurling of national flag, failure to sing or salute, or interrupt or prevent, or any other quirky approach to these solemn duties is just not permissible. So interpreted, in my view, the decision of the Supreme Court to Bejo Emmanuel versus Kerala State of Kerala, AIR 1987 SC 748, needs to be overruled. I will discuss this a little later.
How to interrupt Article 51A?
Let us try to comprehend the notable features of Article 51A. The common opening part of article uses the word shall, which governs all the clauses from A to K. It means beyond any reasonable doubt that all the duties are fundamental, as also mandatory and not just directory. This also means that these duties have to be performed by all citizens without exception, or in any event with least exceptions. In my humble view, the golden rule of interpretation should be adopted uniformly for fundamental duties. That is to say, to ascertain the object and purpose of adding Part 4A to the Constitution and to adopt only that interpretation which would advance the object and purpose underlying Part 4A and eschew that interpretation which would defeat, diminish, or retard the object of insertion of Part 4A. I think since the fundamental duties have been imposed on the citizens, that is, created in favor of the state, the fact that they are not adjust to the state is irrelevant. Therefore, let us see how it works. A child or ward whose parent fails or neglects to perform the duty cast on his parent or ward or his parent under clause K can, after bringing this fact to the notice of the state, move the Supreme Court or the High Court for appropriate relief, compelling the state as well as the parent or guardian to perform the duty mandated by clause K. In this connection, let us compare the three sets of provisions of Part 3, Part 4, Part 4A. The fundamental rights guaranteed under Part 3 of the Constitution have been specifically made enforceable by the combined effect of Article 12, that is defining the state, Article 13, that is uh, providing that all pre-constitutional laws must pass the litmus test of consistency with the provisions of Part 3, and prohibiting the state from making any law that takes away or abridges the rights conferred by Part 3, then laying down the consequences of violation of Part 3, namely that all such laws will be void, and Articles 32 and 226, providing for the constitutional remedies for the enforcement of fundamental rights. Now let's contrast this with Article 37, the provision which makes the provision of directive principles as not enforceable by any court. Thus, Part 4A stands somewhere in between Part 3 and Part 4. Specifically, Part 4 is neither made Part 4A is neither made enforceable nor made unenforceable. None of the judgments holding Part 4A to be non-enforceable has taken note of this important aspect. In this regard, I may notice that in spite of non-enforceability of Part 4A, the Supreme Court in State of UP versus Harishankar Jain, AIR 1950 SC 65, has held that, I quote, mandate of Article 37 of the Constitution is that while this directive principles of state policy shall not be enforceable by any court, the principles are nevertheless fundamental in the governance of the country. Addressed to the courts, what the injunction means is that while the courts are not free to direct the making of any legislation, courts are bound to evolve, affirm, and adopt principles of interpretation which will further and not hinder the goals set out in directive principles of state policy. This command of the Constitution must always be ever present in the minds of judges when interpreting statutes which concern themselves directly or indirectly with the matters set out in the directive principles of state policy. Unquote. The above principle equally applies, in my view, to the interpretation of Part 4A with even greater force, since Article 51A does not contain the non-enforceability clause like Article 37. Moreover, by their very nature, fundamental duties imply some degree of compulsion and enforcement, and consequently, non-tolerance of laxity or permissibility in their disobedience. Uh, Therefore, let us see Clause C, which enjoins citizens to uphold and protect the sovereignty, unity, and integrity of India. Clause D, which requires the citizens to defend the country and render national service when called upon to do so. Latter part of Clause E, which commands citizens to renounce practices derogatory to the dignity of women, and Clause J, that casts a duty on the citizens to safeguard public property and abjure violence.
Is Baiju's Emmanuel case correctly decided?
See, Vijay Emmanuel versus State of Kerala arose from the original petition filed under Article 226 in the High Court of Kerala on behalf of uh, uh, three school children, aged 8 to 10 years. In brief, their case was that they belonged to a Christian sect called Jehovah's Witnesses. The, and chanting of national anthem for this school assembly every morning before the commencement of classes involves worship of God other than Jehovah, which is prohibited in their religion. They applied for exemption from singing national anthem, but the authorities had taken too long a time to decide. Therefore, they filed writ petition because their fundamental rights under Article 19(1)(a) and 25 and 26 were being uh, infringed, which and the state must be restrained from insisting on singing national anthem. Now, the pleadings before the learned single judge disclosed that school education in the state was governed by Kerala Education Act and the rules made thereunder. Rule 9 of Chapter 8 of the rules, the government orders and the circular issued by the Director of Public Instruction thereunder dealt with the singing of national anthem in all the schools of the state since 1961. So for the last 19 years, national anthem was being sung in the schools of Kerala without any protest, and there was no trouble or problem. Students belonging to the same religion, the Jehovah's Witnesses, had earlier asked for similar exemption, which was rejected on 30th of January 1965. Since then, all the students in the school were singing the national anthem. A learned single judge dismissed this original petition on these findings. Number one, the Jehovah's Witnesses is registered as a charitable society and is not a religious denomination, and therefore no fundamental rights under Articles 25 and 26 were infringed. Number two, under Article 51A, showing respect to national anthem by singing is a constitutional duty and mandate, and any exemption from singing national anthem to some students while not insisting on while uh, while compelling the other students would develop a tendency to ignore the constitutional mandate and would have a bad effect on other peoples. On the dismissal of this writ petition, writ appeal was filed by the students before the bench of two judges, which proceeded on the assumption that Jehovah's Witnesses is a religion and went on to decide whether fundamental rights guaranteed by Articles 25 and 26 infringed. The division bench traced the history of our national anthem, and on a reading of the original text and its authentic translation, recorded a finding that India's national anthem is poet's own well-tuned song glorifying India. Now, mark this is a very important finding. The division bench held that it's not a religious song. Its singing is not a religious ceremony, but a patriotic one. The division bench dwelt on India's secular character, wherein all the religions are respected, and noted that no student of other religious faiths had ever made a demand for exemption from singing the national anthem, and the request for exemption made by the children belonging to Jehovah's Witness was rejected on 30th of January 1965, and thereafter all children without exception sang the national anthem without any trouble. The division bench then noticed the reasons that led to the enactment of Prevention of Insults to the National Honors Act 1971, noted its salient provisions, and held that when the entire school shows respect by singing the national anthem, any deviation is not permissible. It amounts to disrespect. It further held, on the basis of the ratio in a number of cases decided by our own Supreme Court, that forbidding to sing national anthem is not essential tenet of Jehovah's Witness. The division bench held that there is not a trace or element of religious worship in the singing of national anthem, and consequently, the religious freedom of the petitioners cannot be said to be abridged by requiring them to sing the national anthem, and there is no violation of their fundamental rights under Article 25 or 26 of the Constitution. The division bench therefore dismissed their appeals and consequently also the original petition which was filed before the single judge. Now the children came to the Supreme Court by way of special to appeal, and civil appeal arose in the Supreme Court. So Vijay and Emmanuel Vijay Emmanuel's case has caused irreparable damage to the adoption of correct approach to the interpretation of Article 2A of the Constitution, apart from being bad in law. It is bad in law because the Supreme Court has preferred to rely on the decisions of the apex court of United States and Australia instead of following a chain of decisions starting from famous Shirur Mutt's case, which has been consistently followed right up to the famous triple talaq case, holding that only such of the practices of religion are held to be fundamental to the profession, practicing and propagation of that religion will be enforced by the Supreme Court. Every little practice cannot be enforceable. It ought to have also followed the decision of Harishankar Jain's case, which I have cited above, and ought to have followed, ought to have evolved. Supreme Court ought to have evolved, affirmed, and adopted the principles of interpretation, which should further and not hinder the goals set out in Part 4A of the Constitution. To my own personal knowledge, a petition for review under Article 137 was filed against the judgment rendered by Supreme Court in Emmanuel's case by the Attorney General during the time of the Prime Ministership of Rajiv Gandhi. Well, I don't know what happened to that uh, review petition. So, in my humble view, a case is fully made out for overruling the decision of the two-judge bench in Bijoy Emmanuel's case. So this is my only take. Yes, I have concluded.
Yes, sir. With all this view on fundamental duties, we will wind up this session. And thank you, sir, for this beautiful session, sir.
Thank you. Thank you very much.